Good afternoon, Professor Madya, Dr. Noraza binti Mat Udin, and fellow classmates. We are from Group 6 and we are going to present Chapter 10, which is about stamp duty. Let me introduce my team. MIAO Zizian, metric number 256858. Chin Chi Wang, metric number 263879. Muhammad Syamim bin Muhammad Sukhairi, metric number 264983. Myself, BRIYANKA anak perempuan NALLIAH, metric number 272446, and THIVEYA THIRSHINI anak perempuan SIVAKUMAR, metric number 272470. The contents of our presentation are Introduction, General Principles, Instruments not duly stamped, Allowance for spoiled stamps, and finally, Penalties.
Hello everyone, my name is XIQIAN. Metric number is 256858. So next I will introduce the stamp duty. First is a brief history. The first legislation on stamp duty was introduced in Malaysia in 1949 under the first schedule of Stamp Duty Act 1949. Stamp duty can be applied as either ad valorem duty, where the amount is payable depending on the value of the instrument transacted, or through a fixed duty. Next is the definition of the stamp duty. In Malaysia, stamp duty is a tax levied on a variety of written instruments specified in the first schedule of Stamp Duty Act 1949. In general terms, stamp duty will be imposed to legal, commercial, and financial instruments, and the stamp duty isn't a static tax. It's changed based on government policy, influenced by market and financial conditions. Stamp duty is paid on a range of property transaction instruments in Malaysia, including the sales and purchase agreement, and no document, no stamp duty. Malaysia's property buyers are also required to pay stamp duty on the instrument of transfer and the loan agreement, as well as for stamping of a tenancy agreement. Stamp duty on the instrument of transfer is often where the more substantial payment required comes in. Then, who should pay the stamp duty? The person drawing, making, or executing the document, or those specified in third schedule to the Stamp Duty Act 1949, and when is it chargeable? Instruments executed in Malaysia which are chargeable with duty must be stamped within 30 days from the date of execution. When the instruments are executed outside Malaysia, they must be stamped with 30 days after they have first been received in Malaysia. Next is a type of duties. There are two types, which is the fixed duty and the ad valorem duty. For the fixed duty, duty is imposed without any relation to the consideration paid or amount stated in the instrument. For example, like the power or letter of attorney, article of association of a company, promissory notes, policy of insurance. The second type is the ad valorem duty. The rate of duty varies according to the nature of the instrument and the consideration stipulated in the instrument or the market value of the properties. For example, like the book debit, goodwill, bond, tenancies, and statutory leases.
Assalamualaikum and hi, my name is Muhammad SYAMIM. My metric number is 264983. So I will continue with general principle, which is liable on the instrument, not transaction. Okay, to understand this, let's say we have two parties, A and B. A want to sell something to B. if there is only verbal agreement between them, so no stamp duty. But if including written document, which is instrument, for example, so it's valid for the stamp duty. We have limitedly versus the Commissioner of Stamp Duties 1956. In this case, several persons trading in partnership under the firm name of limitedly were registered proprietors of trademarks. On the retirement one of his partner, the remaining members applied for registration of the trademark in their name. In support of the application, they prepared an instrument reading and was stamped as receipt in 6 cents. So the result, the commissioner said it is to be chargeable in ad valorem duty, and this was affirmed by High Court. Over the form. So for this, first, the collector of the stamp duties need to determine the nature of the document. Second, stamp duty not only on the form, but also on the substance of an agreement. In easy way, we can say that we need to look into the substance of agreement, not the form. Case THIVEYA and Anna versus Commissioner of Stamp Singapore 1966. In this case, is about claim was made by the lawful widows of the deceased. The parties disputed the ad valorem duties of 4,400 on deed of agreement, renouncing claim to deceased estate on receipt of sum of 220,000. So the result is the deed of agreement was conveyance on sale of property within the meaning of Singapore Stamp Ordinance, in that it was intended to implement an agreement of sale of property and therefore attracted ad valorem duty.
Hello everyone, my name is Chin Chi Mang, and I am going to explain about the subsection of general principles. The leading and principal object. The section 4 subclause 3 says that the instrument should be stamped for its leading and principal object. The stamp duty covers everything accessory to this object, which means that the stamp duty should be charged on this principal object only. This case is related to the principle of leading and principal object. The fact of this case is the 7 appellants entered into a partition agreement and effected cross-transfers of the land means of 3 memoranda of transfer on the subdivision of the land being granted. The collector valued the land described in the 3 memoranda of transfer separately. After receiving the valuation, the solicitors proceeded to have the memoranda affecting the property value at $78,000 stamped with ad valorem duty and the another 2 memoranda with 50-cent stamps. While they presented a stamp memoranda for registration, the collector accepted the memoranda of transfer stamp with the valorem duty only but rejected the another 2 on the ground that they were not properly stamped. The help for this case is that since ad valorem duty had been paid on the memoranda of greater value, the another 2 instruments stamped with the 50-cent stamps were properly stamped. Section 6 says that an instrument containing several distinct matters should be separately and distinctly charged as separate instruments. Whether an instrument falls under 2 separate items of the first schedule of the Act, the collector has the right to collect duty on the item where stamp duty is higher. An instrument falls within 1 or more items of charge, revenue may claim the larger duty. The issue for this case is whether a document is chargeable with duty under 2 categories. The fact is about the United States of Mexico issue gold coupon treasury notes with a promise to pay principal and interest to bearer at fixed dates either abroad or at the option of the holder in London. The document comes within each of 2 categories chargeable with duty under the same Act. The help for this case is that the document contains a promise to pay and therefore in legal phraseology a promissory note. The instrument falls within both of the categories in this distinct taxing act. The crown is entitled to only one of the duties, but it may choose the higher. The result was that it may be assessed under either class at the option of the government. The contingency principle is also one of the general principles, which means an instrument will be subject to the stamp duty by reference to its effect and the circumstances as they exist at the time when it is executed. However, if at the time the relevant instrument is executed, it is not possible to determine the consideration, the stamp office will apply the contingency principle. Under this principle, all contingencies are ignored, and if the relevant instrument sets a maximum limit for the consideration, stamp duty will be payable on this amount. In circumstances where no maximum amount is stated but a minimum amount is set, then the figure will be taken as the consideration payable. Here is the historic case for the contingency principle. The issue for this case is whether a contingency principle is applied. The fact is, a tenant leased two properties. The consideration in each lease included the payment of a premium calculated by a formula based on the price of certain stocks at the close of business of the 25th day after the date of execution of the leases. When the duty payable was determined on each lease, that relied on the contingency principle, which provided that money payable was to be ascertained for the stamp duty charge, without regard to the fact that the instrument might contain provisions which would in certain circumstances prevent it from being payable at all. The commissioners assessed the premium to duty under the Stamp Act by reference to the closing price of a stock on the day before the date of execution, as the stock market was closed on the date of execution. The help for this case is the duty was chargeable on the figure produced by the applying formula in the leases at the date of execution by taking the closing price of the stock on the date. Next, we will be talking about the liability based on the facts existing at date of instrument. The section 5 states that all the facts and circumstances affecting the liability of any instrument to duty or the amount of the duty with which any instrument is chargeable are to be fully and truly set forth in the instrument, and the collector may require such evidence to be furnished as may be reasonably necessary to prove that all such facts and circumstances are truly set forth. The general rule in this section is that the liability of an instrument to duty depends on the facts and circumstances existing at the date of its execution.
Good day everyone, my name is Priyanka. So let me begin my presentation with valuation of duty. So before I explain furtherly, I would like to tell about two different terms that use under these sections. First, the word duty means any stamp duty for time being chargeable under this act or under any written law, while the word executed and execution used with a reference to the instrument not under seal means sign and signature. So now the valuation of duty was discussed under section 12A, section 13, section 14 and finally section 14A. So first let me explain about the section 12A. This section discusses about the assessment of the value of property under transfer or settlement. According to this section, it stated that an instrument is chargeable with duty under item 32 subsection A of the first schedule. The date for determining the market value of any property being transferred, settled or given shall be the date of execution of the instrument of trust or settlement or gift in the case of a settlement of or gift, while in the case of a transfer implementing a sale under a duly stamped agreement of sale and purchase, the date shall be the date of execution of that agreement. Besides that, in the case of a transfer of any property granted by a statutory body, by a local authority or any cooperative society registered under any laws relating to cooperative societies, the date will be the date when the final terms of transfer had been communicated to the transferee, and in the case of subsequent resale of that property, the date of consent by the statutory body or local authority or the board of the cooperative society for that resale. In the case of a transfer under a duly stamped sales and purchase agreement where financial arrangement have been made accordance with the Sharia, the date of execution of agreement, or in any other case, the date of execution of the instrument of transfer. Valuation and Property Service Department, mostly known as JPPH, is one of the departments in Malaysia who is playing important role in valuing when a property is transferred and a transferee is required to pay a stamp duty. So based on this department, this duty is based on the money value of the consideration or the market value of the property, whichever is greater, as provided for under the first schedule of the Stamp Act 1949. Meanwhile, the date of valuation is the date of execution of the agreement when there is a sale and purchase agreement. Otherwise, it is the date of execution of the instrument of transfer. So now I'm going to explain the cases that are related with section 12A. So the first case is Chin, Choi and others versus the collector of stamp duties. The issue of this case was whether the stamp duty payable should be based on the market value on the date of the sale and purchase agreement or the market value when the instrument of transfer was executed. In October 1971, the taxpayer was entered into an agreement in order to purchase a two-story shop from a developer. Although the taxpayer paid a portion of the purchase consideration, the property was only transferred to the taxpayer in June 1973. In order to compute the ad valorem duty payable, the valuation officer used the market value on the date of the execution of the transfer. The collector applied the market value for stamping purposes based on the valuation report and imposed ad valorem duty. The taxpayer contended that the calculation of the ad valorem duty should be based on the value of property as the date of the sale and purchase agreement and not the market value as the date of transfer. So the judge held that the proper assessment was made by the collector as the correct value of property to be applied in calculating the stamp duty payable was the market value. So in this case, the decision was favored to the tax authorities. So the second case is collector of stamp duties versus Fa In and others. So the issue of this case whether the valuation of land is correctly valued or not. So the facts of this case was a land was sold by the taxpayer for 20,000 in Temerloh, Pahang. The collector refused to accept the consideration stated in the memorandum of transfer as the value of the land, and he sent it to the valuation officer in Temerloh for an inquiry and report. The valuation officer valued the land as 12,000 per acre and 122,600 as whole. Following this report, the collector of stamp duty decided that the ad valorem duty payable should be based on 122,600 and the stamp duty payable was 1,452. The taxpayer was dissatisfied with the assessment since the collector assessed the stamp duty payable based on 122,600 instead of 20,000 as what the taxpayer thought. The taxpayer asked the collector to state a case for the High Court's decision on the value of the land. The High Court held that the market value of the land should be 30,000 per acre and reduce the assessment accordingly. The excess of the stamp duties was refunded. The collector appealed against the decision of the High Court. The decision or the judgments was given for this case was the federal court could not interfere with the High Court's valuation as it has acted correctly on the principle of law, and the valuation was correct after taking into consideration the evidence and submission of the counsel from both parties. So in this case, the decision was favored to the taxpayer. This is the third case, Pemungkut Duty SAM versus BSF Services Malaysia Sdn Bhd. The issue of this case, whether the infrastructure fee is a part of the consideration in the transfer instrument and therefore attracts stamp duty. The facts of this case was the appellant had made an assessment of stamp duty to be paid by the respondent in respect of a piece of property in Kuantan, Pahang. The respondent had appealed against the assessment to the High Court. The High Court held that stamp duty should be based on two components, which are the purchase price in respect of the property and the development fee. A third component, the infrastructure fee, should be excluded. The appeal was allowed and the assessment by the appellant was set aside. The appellant aggrieved by the High Court's decision and appealed to the Court of Appeal. So the judge held that by allowing the appeal, setting aside the decision of the High Court and affirming the appellant's assessment. So one of the considerations when making the decision by the judge is that the instruments in this case refer to the Purchase, Development and Infrastructure Agreement, which is chargeable with stamp duty, and the date for determining the market value of the property being transferred according to Section 12A subsection B of the Act shall be made the date of execution of the said agreement, which includes all three components. According to Section 13 of Stamp Act 1949, it stated that when an instrument is chargeable with ad valorem duty in respect of any money expressed in any currency other than ringgit, or any stock or marketable or other security, the duty shall be calculated on the value on the date of the instrument, or on the date it is stamped if executed out of Malaysia, of the money in ringgit according to the current rate of exchange, or of the stock or security according to the average price thereof, or if there be no price according to the value thereof. Moreover, an instrument contains a statement of current rate of exchange or average price, as the case may require, and is stamped in accordance with such statement. It shall, so far as regards the subject matter of such statement, be presumed until the contrary is proved to be duly stamped. Section 14 is about instruments reserving interest. When terms of an instrument mention about interest that made payable, hence stamp duty is not chargeable on that instrument with hire unless if the instrument didn't mention about the interest. So in this case, United Malayan Banking versus Pekeliling Trial Sdn Bhd and another appeal, the issue was about whether stamp duties were payable on the interest capitalized. Actually, there were two principal issues were connected with two sections, which are Section 28 and Section 14. The principal issue in these cases was concerned with the constructions of Section 28 of the Act, that is, whether interest which is capitalized under a charge document still retain the character of interest, so that stamp duty is chargeable on the original loan amount only under Section 28 subsection 1 of the Act, while another principal issue that related with Section 14 was raises question whether such capitalized interest is interest for the purpose of Section 14 of the Act, so that no stamp duty is chargeable on it. So let's have a look on the facts of this case. A sum of money was borrowed by the respondents, who is the Pekeliling. The respondents failed to pay the principal amount and interests which were capitalized and added to the principal sum at the end of each month. The respondents defaulted in payment and the bank applied for an order for sale of the lands which were charged to them. The High Court ordered the proceedings to be stayed pending the payment of stamp duty on the interest which was capitalized under the charges. The bank appealed against the High Court's decision. Okay, the court held that the capitalized interest was similar to the compound interest. It retained the character of interest when unpaid and therefore does not have to be stamped separately. Therefore, only principal amount was chargeable to stamp duty. Section 14A stated that where it is shown that a principal or primary security secures the repayment of money provided under a scheme of financing made according to this Sharia, duty chargeable thereon shall be calculated on the principal amount provided by the financier or financing body. Now I'm going to explain the payment of duty. The person who liable to pay the duty can be made the payment at any LHD&M stamp duty branch offices and revenue service centers with the following modes. So the payment can be done in the form of cash or adhesive stamp, also known as revenue stamp, if the duty does not exceed RM 500, or using money order, solicitor's check, or bank draft that made payable to the collector of stamp duty and submitted together with the relevant instrument to the stamp duty office by hand or through registered post. Okay, besides that, the payment can also be made at district offices but restricted only modes of payment, which the payment can be done using revenue stamp and the amount duty payable does not exceeding RM 500. The payment of duty of an instrument may be denoted by the impressed stamps through the use of digital franking machine. Stamp certificate in relation to the instrument to the value of the duty paid is issued electronically, where stamp application is done online via the internet at LHD&M website. The certificate should be affixed or attached to the instrument, and the instrument shall be deemed to be duly stamped. And the third, adhesive stamps or revenue stamps can be purchased at all post office in Malaysia. The revenue stamps are available in the following denominations, which are 1 ringgit, 5 ringgit, 10 ringgit, 50 ringgit, 100 and also 250 ringgit. And finally, through the issuance of Q38 receipt. According to Section 8, it allows Minister of Finance by license under his hand to authorize any person to pay the duty on any of the instruments that specify in the 5th schedule by means of a postal franking machine or digital franking machine. And finally, the Section 9, it allows the authorized persons to compound for the payment of duty on certain instrument. So the collector may authorize any banker, dealer or issuer to compound for the payment of duty on unstamped checks, contract notes or policies of insurance, while the Register of Companies can compound for the payment of duty on unstamped Memorandum of Association and Articles of Association. And the principal officer of Tenaga Nasional Berhad allowed to compound for the payment of duty on the unstamped TNB electric supply form.
Hello, good day my dear friends and lecturer. My name is THIVEYA, daughter of SIVAKUMAR. Today I'm going to present on instrument not duly stamped. Okay, now let us look into the first part, which is examinations and impounding of instrument, which fall under Section 51 in Stamp Act 1949. There is two subsections in this particular section. So the first subsection can be simplified as every person having by law or consent of parties authority to receive the evidence, and every person in charge of public officer except an officer of the police before whom any instrument is chargeable in his opinion with the duty is produced or comes in the performance of his function. So, such instrument is not duly stamped and impound at the same time because it is breach of the law. Okay, now let's us look into the second subsections. So, it stated that every person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it's stamped with the stamp of value and description required by the law enforced in Malaysia when such instrument was executed. So provided that A. The document required by magistrate or judge to examine or impound if he thinks does not fit any document coming before him in the course of any criminal proceeding. So second one, in the case of judge, the High Court, the duty of examining and impounding any instrument under this section shall be performed by the registrator. So this is the first case, which is Abria versus Azinol, which can be used for section 51 and 52. So the issue for this case is who should pay the duty and penalty and the document unstamp and impound. So the fact of the case is the respondent contracted to build a house for the defendant. So they had into several written agreement. So in this case, they had a common ground that one of the document was chargeable with stamp duty, but he did not be stamped at all. So in the quote below, the learned president applying section 52 of Stamp Duty Act 1949 considered that the document was immiscible and ignored its context by way introducing the background. On appeal, the defendant applied by notice of motion for the High Court to impound so that after the payment of duty and penalty, it might be admitted and its context to be taken into account. Hence, the defendant applies by notice of motion for the court to impound the document so that after the payment of duty and penalty, it can be admitted and its context taken into the account. So, her counsel states that the learned president should have impound the document under section 51, but owing to oversight, failed to bring the section to the notice of learned presidents. So the document should be normally have been stamped before or at the time of execution according to section 41, but it also can stamp after the execution on payment of penalty in addition to stamp duty, which is section 47. So this is the appeal is hearing and the court can do he should have be done. The document was all the time plaintiff position. The appeal will resume after the document was received back from the stamp duty office on the date to be fixed by the registrator. So the decision of the case was they should be normally have stamped before or at the time of accusation, but it also could be stamped after the accusation on payment of penalty in addition of stamp duty. Moreover, in this circumstance, the defendant should pay the whole amount of duty and penalty. Okay, now let us look into the second one, which is instrument not duly stamped, indivisible in evidence, is fall under section 52 subsection 1 in Stamp Act 1949. So, which means no instrument is chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties of authority to receive the evidence or shall be act upon registrator or authentic by in such person or any public officer unless in such instrument is duly stamped. So provided that the first one, any such instrument shall be subjected to all exceptions to be admitted in evidence on payment of duty and penalty, if there is any, chargeable in respect therefore under section 43 and 47A. So there is no document contained shall be prevent the admission of any instrument in evidence in any criminal code. The last one, no document contained shall prevent the admission of any instrument in evidence in any code when such instrument has been executed by or on behalf of the government of Malaysia of the collector as provided by this Act. Continue in section 52 subsection 2. No instrument execute outside Malaysia and relating to any property situate or any matters or anything to be done in any part of Malaysia except in the circumstance mentioned in subsection 1. Okay, be given in evidence or referred to use in any manner in any proceeding in any courts or before any tribunal, board, commission, community and similar body by whatever name is called. Therefore, establish under any written law unless it is duly stamped in accordance with the law force in Malaysia at the time when it is first execute relating to stamp duty which could have been chargeable on any such instrument if it is being executed in part of Malaysia. So the next one is section 52 subsection 3. In subsection 2, mention that part of Malaysia include any territory which is part of Malaysia at the time of proceeding with notwithstanding that it was not part of Malaysia when the instrument was executed. Now let us look into the first case, which was Al-Ghaffar Chediyar versus Freedom Shah bin XIQIAN under section 52. So the main issue was whether the both memorandum were admissible as evidence or not. So the fact of the case is an individual borrows some money from the moneylender using his share in certain land as a security. So the memorandum of agreement and memorandum of trust were executed. So the individual has failed to repay the loan and the moneylender has applied for an order for sell the shares in the land. So the individual argued few things. So the first one is he argued that he did not receive an authentic copy of memorandum of agreement. The second thing, he claimed that for repayment of loan was statute bar, and the third thing, he stated that the memorandum of agreement was not properly stamped. So by this, the judge has rejected the first two arguments but held that the memorandum of agreement was a promissory note and it could not be used as the evidence as it was not properly stamped, and the memorandum was charged did not provide for the interest and was not signed by the moneylender. So the judgment for the case is the memorandum of agreement did not have to be stamped and it was not a promissory note, but both of the memorandum were inseparable and such the date of the loan was not omitted. The memorandum of agreement had clearly provided for interest. The charge was fact executed. Okay, the second case is Shah Hamid versus Mustafa under section 52. So the main issue was stamp on document not cancelled and the document demand to be unstamped. So the fact of the case was, this was an election petition in which it was prayed and it was to determine that the respondent was not duly elected as the member for the parliamentary constitution of Tanah Merah Kelantan to the Dewan Rakyat. So the main problem for the petition was the statutory declaration submitted by the respondent with his nomination paper was invalid as the stamp on it not be cancelled in prescribed manner, and therefore the returning officer was wrong in accepting the nomination paper of the respondent. So it's clearly that the stamp affixed, therefore not having to be cancelled in the prescribed manner, it must be deemed to be unstamped, and therefore it is immiscible in evidence and cannot be acted upon for any purpose. The point is whether the stamp has been cancelled in such a way was the word in section 7 subsection 5, it cannot be used again. So the provision A to the section 52 cannot be invoked in this case, as then there is no evidence that at the time the petitioner was made his objection to the document the respondent has paid the duty or penalty or have been given any undertaking in the respect of such payment. So the judgment was, as the stamp on statutory declaration has not been cancelled in a prescribed manner, the statutory declaration must be deemed to be unstamped and therefore immiscible in evidence, could not be acted for any purpose. Therefore, as there is no valid statutory declaration, the returning officer should have rejected the respondent nomination paper, as it was not done in this case, and there was a non-compliance with the provision of regulation relating to the election. Now let us look into the third part, which is agreement evidence by letter house stamped, and it falls under section 55 in Stamp Act 1949. So the first subsection stated that a contract or agreement will affect by connections consist of two or more, and any one of the letter bear the proper stamp, the contract or agreement shall be deemed to be duly stamped. So following by the subsection 2 stated that an agreement is evidenced by one or more letters between parties. So the letters were not stamped before being used, and it shall be lawful for the collector on being certified that the omissions to have the letter or the letter stamp did not arise from the intention to evade the payment of stamp duty. So the third one is any stamping on any letter under the section, the collector shall write or cause to be written on the letter the words of duly stamped, and shall add his signature or initials on the day, month and year on which the letter was stamped. The last subsection stated that when a letter is stamped, all the letters forming together the agreement may use in evidence to prove the agreement stated or partially stated in the letter also stamped. So that's all from me. Thank you.
Section 56 of Stamp Act 1949 was discussed about the recovery of duty and penalty. By any agreement or under this Act, if any person paid any duty or penalty in respect of any instrument, and when such instrument was executed or first executed, some other person was liable to pay the duty on such instrument, and the first mentioned person shall be entitled to recover from such other person the amount of the duty or penalty so paid. Later, the collector will provide any certificate granted for the purpose of recovery in respect of such instrument. So the certificate granted will be a conclusive evidence as to the amount of the duty and penalty paid, and the person by whom they be paid.
For the spoil stamps, this allowance is not about the money allowance, but it's actually more to permission, which is starting from section 57 until section 59, Stamp Act 1949. In section 57, supposedly they have 5 parts, which is A, B, C, D, F, but one is already deleted by Act 661, which is C. Section 57C. Section 57A, the most important thing is at the sentence before the paper bear the signature, which is meaning is allow for allowance for the spoil stamp if the paper do not sign yet by any parties. 57B, the important thing you have to concern that at the sentence has not in the opinion of a collector has been affixed to any papers. The collector here refer to IRB and Minister of Finance, perhaps because they are the collector for the stamp duties. For section 57D and E, actually is more related to promissory notes. Before that, promissory note, we have a maker and the payee. The maker is the one who promised to give sum of money, while the payee basically is the one who will get the money. For 57D, stated that stamp on any promissory note signed by or on behalf of the maker which has not been made use of in any manner whenever of delivered out of his hand. For 57E, stated that the stamp on any promissory note which from any omission or error has been spoiled or rendered useless, although the same being promissory note may have been delivered to the payee, provided that another complete and duly stamped promissory note is produced identical in every particular except in the correction of the error and omission with the spoiled notes. 57F, the stamp used for any of the following instrument. First, an instrument executed by any party thereto, but afterward found to be absolutely void from the beginning. Two, an instrument executed by any party thereto, by afterward found unfit by reason of any error or mistake therein, for the purpose originally intended. Third, an instrument executed by any party thereto, which has been made use of for any purpose whenever and which by reason of inability or refusal of some necessary party to sign the same or to complete the transaction according to the instrument is incomplete and insufficient for the purpose for which it was intended. Number 5, an instrument executed by any party thereto, which by reason of inability or refusal of any person to act under the same or for one registration within the time required by law, fails of intended purpose or become void. Number 5, an instrument executed by any party thereto, which is inadvertently and undesignedly spoiled, and in way of another instrument made between the same parties and for the same purpose is executed by duly stamped or which become useless in consequence of transaction intended to be thereby being affected by some other instrument duly stamped.
Now let me explain about the stamping of instrument after execution. According to Section 47 of Stamp Act 1949, it's stating that all other instruments that unstamped or insufficiently stamped, except promissory notes or checks that drawn or made within Malaysia, may be stamped after execution on payment of the unpaid duty if the instrument is presented for stamping within 30 days of its execution if executed within Malaysia, or if the instrument has been executed outside Malaysia it should be stamped within 30 days after it has been first received in Malaysia. This is the example of case that related with section 47, the case about Navaratnam versus Supaya Chediyar that reported in 1973. The facts of this case were 3 promissory notes had been brought by the respondent on an action. The promissory notes had been stamped after they were signed by the debtor. On objection being taken, the President of the Sessions Court held that the promissory notes were not admissible in evidence as they were not properly stamped according to the section 52, and he dismissed the matter. After that, the respondent appealed to the High Court and Sharma J allowed the appeal, holding that the promissory notes could be stamped before or at the time of execution so as to cover a reasonable period of time after execution. The appellant appealed to the Federal Court. The court held that the promissory notes in this case were only stamped after they were executed, they were not duly stamped, and they were inadmissible in evidence. Now I'm going to explain about the penalty for late stamping. If a person failed to stamp within the period stipulated, the person need to pay penalty for late stamping according to the section 47A subsection 1 of Stamp Duty Act 1949. If the person stamped within 3 months after the time for stamping, as for penalty, the person need to pay 25 ringgit or 5% of the deficient duty, whichever is the greater. Meanwhile, if the person stamped after 3 months but not later than 6 months after the time for stamping, the penalty will be 50 ringgit or 10% of the deficient duty, whichever is the greater. And the last one, the person need to pay 100 ringgit or 20% of the deficient duty, whichever is the greater, if the person stamped after 6 months from the time for stamping. And then according to section 47A subsection 2 of Stamp Duty Act 1949, the collector may reduce or remit any such penalty if it thinks fit. That's all. Thank you.